Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada but didn't. Today we're talking about prior testimony. Cases that should have gone to the Supreme Court of Canada but didn't. In a preliminary inquiry, a person has the opportunity to cross-examine witnesses, and there is a transcript of that testimony that is created. In some circumstances, that witness may not be available at trial, but may be required or desired to attend by either the accused or the prosecutor. In such circumstances, the court can permit the earlier testimony from the preliminary inquiry transcript to be admitted into evidence in violation of the hearsay rule because of the principled exception that it is necessary and because of the opportunity for cross-examination and testing the evidence generally considered to be reliable. In other circumstances, statements made out of court can also be admitted where a witness is unavailable if they're given in circumstances that show that they were likely to be reliable and that they are necessary. And this is the conflict that arose in a particular case where the preliminary inquiry transcript was admitted into evidence, but the same individual who couldn't testify and had testified at the preliminary inquiry had given an out-of-court statement in a police interview, and that was not admitted into evidence. And certainly there's no general proposition that a police interview statement is going to be unreliable, and unless unreliability was a concern, the argument was that this statement should have been admitted. And this case raises very important issues when it comes to the hearsay rule and the application of the hearsay rule, specifically in relation to reliability of witnesses where these shortcuts or exceptions to the hearsay rule are being provided. In the preliminary inquiry process, there is an opportunity to cross-examine an individual, but there also may be strategic decisions made either by Crown or defense to not ask about a certain area or a certain topic, and to not ask about certain inconsistencies to save the surprise element of that for trial. Or the preliminary inquiry may be used to set up the potential for an inconsistency with the intention that the person is going to seize upon that at trial to demonstrate the witness is not telling the truth. There are strategic decisions made in a preliminary inquiry about what to ask and not ask for those reasons, even where there's a prior interview. And that's why, in a circumstance where the statement from the preliminary inquiry is admitted, but the statement that is made to the police is not, could potentially limit the ability to make full answer in defense. And unfortunately, I think the Supreme Court of Canada failed to see the extent to which these strategic decisions may impact a person's ability to respond to the charges and may potentially lead to wrongful convictions, may potentially lead to the innocent people being found guilty because they can't properly challenge the evidence of witnesses who they expected to be at trial, but who are, for whatever reason, unavailable to testify at trial. It's unfortunate the Supreme Court of Canada didn't see the way in which the two are often tied to one another, and that admitting one should lead to the ability to admit the other without having to have the court deny that opportunity just because one is already being admitted. Hopefully the Supreme Court of Canada does deal more with these strategic decisions by Crown and defense in the future so that there aren't situations where somebody is denied the ability to make full answer in defense. Cases that should have gone to the Supreme Court of Canada but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.